You see legal frameworks, ideas about contracts, property, and rights, flowing from Europe into Africa. But upon arrival, the systems crash. They fragment. For decades, contemporary African legal systems have functioned in this state of friction, governing with transplanted colonial models that pull against the social realities of the continent. The dominant export in this intellectual exchange has been Western legal positivism. Positivism attempts to define law by looking at its formal sources, like parliamentary statutes, while aggressively separating it from morality and social context. This creates a severe form of epistemic injustice. Because indigenous African customary law is deeply rooted in communal values rather than formal state statutes, Western theorists historically marginalized it, dismissing complex African societies as merely pre-legal. Confronted with this bias, one academic response is the exclusive approach, a push to isolate African scholarship and reject all global legal theory outright. But this creates an intellectual dead end, cutting off valuable comparative learning. Instead, philosopher Kwasi Wiredu advocates for the inclusive approach. This method demands that African thinkers critically engage with universal legal theories, forcing them into a dialogue with African contexts to promote genuine intellectual diversity. Decolonizing jurisprudence requires us to take dominant Western theories and stress test them against rigorous African philosophy, breaking down colonial biases to build a truly responsive legal framework. We begin this stress test with one of the most famous positivist models, John Austin's command theory. Look at this model. He defines law strictly as the command of a sovereign, exerting downward force on a populace, backed by punitive sanction. But apply that coercive model to traditional African societies, and the structure fractures immediately. To understand why, we look to philosopher John Beatty, who mapped the anthropology of traditional African kinship societies. He found that the individual exists only in relation to a vast, continuous community, including ancestors and the unborn. Beatty describes a horizontal, decentralized web. These societies managed order through profound relational interdependence. Notice how energy flows horizontally here. These facilitative norms enable cooperation and social harmony, rather than punish from absolute authority. Austin's top-down mechanism fails here. By demanding coercive authority, his theory cannot recognize the communal consensus that successfully governed African life for centuries. Next, we test the work of Austrian jurist Hans Kelsen. Kelsen developed a highly abstract system where every legal norm derives its validity from a higher basic norm, culminating in what he called the Grundnorm. This illustrates Kelsen's demand for legal purity, installing a hard barrier to isolate the legal system from the fuzziness of social morality. But when we introduce African living customary law, that artificial barrier dissolves. The South African philosopher Mogobe Ramose articulates this reality through the concept of Ubuntu, a philosophy prioritizing human interconnectedness. Under Ramose's Ubuntu conception of law, legal validity and communal morality are the exact same interconnected substance. You cannot evaluate whether a customary law is valid without simultaneously evaluating whether it serves the moral well-being of the community. Any jurisprudential framework demanding the absolute separation of law and morality becomes structurally blind to how an Ubuntu-based legal system maintains restorative social equilibrium. Finally, we turn to the highly influential British philosopher H.L.A. Hart. Hart defined the law as a union of rules, dividing it into primary rules, which dictate human duties, and secondary rules, which tell a society how to recognize, change, and adjudicate those primary rules. Think of secondary rules as bureaucratic machinery, the mechanics of formal courts and legislatures. Hart controversially concluded that societies without these specific gears cannot have a true legal system. He dismissed them as pre-legal. This conclusion conflicts with the documented history of African customary law. Traditional African societies continuously managed property disputes, negotiated trade, and maintained complex social order without Western bureaucratic statecraft. Their mechanisms of consensus and restitution were highly organized, even if unwritten. By equating the absence of European-style bureaucracy with the absence of law entirely, Hart commits a profound epistemic injustice, erasing the sophisticated governance of millions. So how do these theoretical debates shape the actual practice of law today? How should a modern judge adjudicate in a newly democratic, post-colonial African space? To answer that, we revisit Hart briefly to examine his thoughts on the limits of language. He famously used the example of a rule stating, "No vehicles allowed in the public park." Hart maps this problem out. There is a solid core meaning, surrounded by a hazy, ambiguous outer ring called the penumbra. If someone rides a bicycle into the park, it lands here. At this edge, strict, mechanical rule-following breaks down. Theorists like Lon Fuller and Ronald Dworkin counter that judges cannot just look at the dictionary definitions of words. They must examine the purpose, the context, and the social aims of the statute to find an answer. When the text itself offers no clear path forward, a judge relying solely on formal rules hits a wall. This illustrates why a transition towards substantive, value-driven reasoning is required for a society undergoing radical democratic change. The practical application of the inclusive approach addresses this exact problem, taking shape in the form of transformative constitutionalism. As the late Chief Justice of South Africa, P.S. Lunga, articulated, African courts must explicitly reject purely formal reasoning. Adjudicating a new constitutional era requires deeper, substantive reasoning driven by values and principles. This framework requires judges to go beyond Western positivism and actively integrate the communal, restorative values of Ubuntu directly into their interpretation of state law. When constitutional law is empowered by indigenous philosophy, the rigid boundaries of positivism break open, expanding to consider the society's moral values. The court's mandate moves beyond the sterile application of rules toward the active healing and transformation of society. The inclusive approach does not discard global jurisprudence. Instead, it forces it to evolve, holding Western theory fully accountable to the complex realities, the history, and the future of the African continent.